final session of MMPC 13 in continuation of previous sessions in which we were talking about. We were exploring the block 5 IPR and data management, in which an interesting aspect of intellectual property rights in unit 10 was explored. There is another evolving and relevant aspect also, that is data protection and privacy. As far as the data protection and privacy is concerned, let's start with exactly because you are a management learner for the management. The concept of data is not new, as well as the importance of data is also not new. It is very in-depth aspect. One data that may be a raw information for one person, organization, or individual may be crucial for another organization to plan, to progress, to make some policy decisions as well. But at the same time, who has the access, who can store it, or in what manners the data can be utilized needs a thorough understanding and a structured legal framework umbrella as well. Well, we can say so, one of the primary factors that over the period of time necessitated the evolution of privacy of rights was the need to safeguard and preserve the dignity of an individual and consequently preventing unauthorized disclosure of personal information in the public domain. We have witnessed, because it's an internet age, we used to sign a lot of mandatory disclosures. We need to sign, maybe we need to give our consent to a lot of conditions while accessing a website, subscribing to some services. So under those conditions, what are our rights that are protected and the organization is bound to follow it, are all mandated usually. But what happens is the font size is very small, and maybe it's a urgency or hurriedness. We used to skip exactly the terms, concept, and the after effects of those conditions and options if we are able to accept, deny, or modify it. So usually we skip them, and only option we prefer is I agree. The repercussions and effects may be seen in the later stage. To address such issues, to address the issue of one-sided agreements, to address the issues of subsequent disclosure of these informations to the third parties or in public domain, the concept of data protection and privacy was evolved, and it was all together in the process of evolution as well in the current scenario as well. We used to see day-to-day modification in this, and definitely it's a very, very interesting aspect that it is co-evolving with the evolving scenario in the surroundings over the period of time. Well, as for Samuel D. Warren and Louis D. Brandeis, those who are the two earliest scholars who contributed immensely in the process of evolution of privacy laws. So, privacy is a concept encompassing the inviolate personality of a person, which does not include within its ambit matters which are privileged, published with consent, or existing in the public domain. In Indian context, the Constitution of Indian Constitution itself does not explicitly mention the right of privacy, because the Constitution was framed in 1950. At that time, maybe this was not a topic of discussion, or it doesn't have such a relevance at that time, considering the situation some 70 years back. everything was not accessible to that effect, and we just got our freedom, independence or so. So it was not, maybe not a relevant topic at that time. But over the period of time, considering the spirit of constitution, courts in India have dealt with the question of whether privacy is a fundamental right in India or not. Well, in a specific case of MP Sharman versus Satish Chandra, decided by an eight-judge bench of Supreme Court, which deals with the questions regarding the legitimacy of a search warrant issued under Section 96, subsection 1 of the CRPC 1973, and was the first ever case to touch upon this aspect, specifically with reference to the privacy. As per the direction of the court, a data protection regime was set up to safeguarding individual interest in relation to infringement of privacy. Later on, government formed a committee of experts under the leadership of Justice B.M. Shri Krishna to consider all issues related to data protection and come up with a draft legislation thereon. In subsequently, there was a act that we very commonly call as IT Act 2000, which has got some implication with reference to privacy protection. And the Rule 3 of IT rules in 2011 gave a definition for sensitive personal data or information, means any such personal information which consists of information related to password, financial information such as bank account or credit card, debit card, or other payment instrument details, physical, physiological, and mental health condition, well, sexual orientation as well, medical records and history, biometric information, any details relating to the above clauses are provided to body corporate for providing services. And any of the information received under above clauses by body corporate for processing, stored or processed under lawful contract or otherwise. Well, the right to privacy, there is definitely a need for a specific data protection law. The protection of privacy in current digital context requires framing of specific policies and procedures that can minimize the intrusion of private persons, including companies, and the state into the privacy of an individual by generating, collecting, sorting, well, storing, using, collecting, and deriving data about the individual. So here you can see there is an additional aspect of deriving data also. Like there are series of information, like information 1 and 2 or 3, and out of those 3 information, another one can be derived. So that derived data is also relevant under the right to privacy of the individual's data. Well, the individual data is categorized into 2 categories. One is called as personal data, and another is non-personal data. Personal data may contain characteristics or traits which may be used to identify an individual, while non-personal data, on the other hand, encompasses aggregated data which may not serve in identifying an individual. Well, in Indian context, we understand that the right to privacy or data protection framework was evolved on the basis of the decision of Puttaswamy, Supreme Court order categorically mentioned to need for an appropriate data protection framework in India. And in 2017, the Indian government decided to form a committee, which we discussed earlier also, to explore various dimensions of data protection and suggest inputs for an appropriate legislative framework in this context. Well, under chairmanship of Justice retired B. Shri Krishna, the committee gave a comprehensive report delineating the rationale for a robust legal framework for data protection, and the committee also provided personal data protection bill as well. There is a concept of data fiduciaries. Data fiduciaries are those who receives data, and they are supposed to follow certain principles. The 3 major principles are purpose limitation, providing notice, and storage limitation. As mentioned, purpose limitation means data fiduciary shall use the personal data collected only for the purpose for which the data principal expects it to be used, sort of transparency. Here, two terms are emerging. One is data principal, another one is data fiduciary. Data principal is the one whose data is there, and data fiduciary is there who is holding or receiving data. Well, providing notice right at the time of collection of personal data, notice is to be provided why you are collecting data, what can be its use. So the data principal knows exactly what purpose this data is being collected, how it is to be stored, how long it is to be handled, or like that, who's going to handle. So data principal has a right to get the information about that. Then storage limitation. Storage of data only for a time period required to fulfill the purpose for which it was collected. It cannot be stored for endlessly, so it used to lapse after some time or a specified time. Well, the processing cannot be performed in the absence of an express consent by the data principal unless the purpose for the same has been communicated at the time of collection. Well, here I mentioned in the previous session that derived data also. So it cannot be done without the consent or the information. Committee also recommended the inclusion of data principals' rights to certain aspects. The rights of a data principal include he can object to processing, he can select the option of correction. Well, he can confirmation on data principal's right to inquire about the processing of his or personal data. While data portability, right to receive and transfer the data stored with the data fiduciary. Access, he has a right of the data principal to obtain access to his personal data in the control of data fiduciary. He can object to direct marketing. Well, he can go for to be forgotten. Well, right of the data principals to delink, amend, or correct the information that may be disclosed on the internet by the data fiduciary. Well, the Personal Data Protection Bill 2019 introduced in Lok Sabha 2019, and it was subsequently forwarded to the JPC. While the bill has retained some main elements of the draft bill provided by the Shri Krishna Committee, well, it has also made some radical changes also in terms of members and other things. Some changes were incorporated. Well, as far as the definition of the personal data, which was defined in a way so as to include characteristic traits or attributes of an identity used to identify an individual, was expanded to also include any inferences being drawn from such data for the profiling purposes. Well, the composition of Data Protection Authority was also suggested certain modification in 2000 PDP bill. The selection committee, as per 2000 bill, consists of cabinet secretary as chairman, secretary Department of Legal Affairs, secretary Minister of Electronics and Information Technology. Well, that was altogether interesting aspect about the data protection and privacy. So let's move to the next block. It is the business and sustainability. As far as the concept of business is concerned, business is nowadays governed and covered and faced a lot of issues, and they need to work in a synchronous manner so that it to survive. In this block, we will be exploring the environmental protection and sustainability, because over the period of time, due to industrial activities, there has been a lot of damage to the environment, and environment is something which is directly related to the life and living of individuals. So if the environment is deteriorated to the level, to the sense that it is going to be harmful for an individual to survive in that scenario, so that cannot be done. The legal framework of this country, any country including India, prohibits the taking away of life without the procedure and the methods that is prescribed in the law for the specifically for the criminals, not anyone can. Whereas any modification or alteration or change in the environmental condition directly indirectly affects the life. So that is one aspect. So that was introduced, or that is also very evolving with reference to this law. Then competition law, that industries can survive, grow, but cannot crush other industry in a manipulative manner. It is already in the competition law. And then the one of the interesting aspect that has evolved is something. So far, business law may be there to facilitate the operation of business, but in a business, in any business activity, we cannot ignore the consumer. So here, it will be discussing, we will be exploring the discussions with reference to the protection of consumers' law, rights, and how it is evolved. And that too in the current scenario when we are in the IT age, and in the IT age, there are a lot many things that are evolving over the period of time, including e-commerce and sort of things. So problems, opportunities, and responsibilities that are evolving are also introduced in this particular unit. As far as the environmental protection is concerned, over the past, specifically if we say so, past 50 years or so, the world has developed ample understanding on the relationship between human beings and the environment. As per Stockholm Declaration adopted by the UN Conference on Environment in Stockholm 1972, placed environmental issues at the forefront of the international concern and marked the start of a dialogue between industrialized and developing countries on the link between economic growth, the pollution of the air, water, oceans, and well-being of people around the world. Well, as far as the 2030 agenda of SDG, Sustainable Development Goals, adopted on September 2015, which includes 17 Sustainable Development Goals, especially SDG 9, T3, and the SDG 1, 2, 4. So, puts the onus of sustainable development not just on the governments but also on other stakeholders like industries, businesses, and consumers under the international framework of climate change. Kyoto Protocols and Paris Agreement have both called for the financial assistance from developed countries with more financial resources to those countries that are more vulnerable as less financially endowed. Further, the Paris Agreement has been unprecedented participation of several companies, including Mahindra Group from India, showcasing their green technologies and pledging to reduce greenhouse gas emissions at the Caring from Climate Business Forum. Well, it is important to imbibe a culture of sustainability and profitability with clean and sustainable technologies within the corporate structure as well. Considering the same, we nowadays see a lot of technologies, a lot of industries that are also exploring the option of green technology. Nowadays, the as a fuel, because automobile industry seems to be major culprit in polluting the environment. So we look forward, or we see a lot of green vehicles running on the exploring the concept of hydrogen fuel based, exploring the concept of electric buses as roaming around. So this way, a lot of changes are visible or upcoming in coming days. Well, International Finance Corporation in its report says that climate financing cannot be done by governments alone. In fact, private entities are far more suitable to invest in climate-friendly projects. Well, it further states that between 2018 to 2030, US dollar 3.4 trillion dollars of climate investment opportunities in key sectors will arise in South Asia itself. Well, if NDCs are met by countries in South Asia, out of this, US dollar 3.1 trillion dollar opportunity will be presented in the India alone itself. So you can see like zero point 0.3 trillion for the rest of South Asian countries and only and whopping 3.1 trillion dollar for the India only. Well, it may be reason for the size of the country, the population, the development. So all those aspects consider the differences there. Well, the global economy, if we say so, it is expected to triple by the 2050. There is a at the same time there is a possibility of which is altogether quite possible, no exception to this. It is like the possibility of widespread human population, especially in developing countries, wherein the current population is around 7.3 billion. Well, it is expected to reach 9.7 billion by 2050. Well, there will be increase. There is definitely going to be an increase in global consumption, manufacturing, pollution levels, and we are nowhere near to achieving the targets set by the Paris Agreement. And also, we are facing the 1.5 degree Celsius temperature increase as well, which will further aggravate the negative impacts on our environment, livelihood, and health. So here I need to mention that if we assume or we see temperature increase, so maybe it's a very fractional temperature increase. 1.5 degree doesn't seem to be very, very high. But considering the situation, this 1.5 degree is an average temperature. So at some point of time, this will be higher, and at some place of time, it may be lower. So overall average temperature rise is expected to be 1.5 degrees Celsius. And assumably, if this temperature is higher at some place, the temperature, because for us, for human beings, it may not be that much of problem because we are living in a proper shelters, we have a proper housing, we have a provisions for facing winter and summers or odd situations. But there are certain organisms or parameters to which we depends, like plants. So if temperature rises, so it will attract another problem of depletion in water level, depletion in uh, plant growth, depletion in crop production, increase in desertification. So that effect will be indirectly affected. So as far as the evolution of environmental protection legislation in India is concerned, well, India's approach towards environmental protection was piecemeal and reactive in nature. Well, in specifically in response to Stockholm Declaration of 1972, air, air, water uh, prevention and control of pollution act was introduced in 1981 and 1974 respectively. Further, as per Article 48A and 51G, the Constitution was amended by 42nd Amendment also to deal with certain scenarios. While it is unfortunate to know that beyond causing continual environmental harms, industries can also be responsible for severe and large-scale disasters resulting in the death of millions of people. India was ill-fated to witness one of the world's worst industrial disaster in the form of Bhopal gas tragedy in 1984, killing thousands of people and disabling a lot more in years to come. Well, that incident was a turning point for environmental jurisprudence in India. Several prominent legislations, rules, notifications were adopted after this incident, taking into account issues and challenges that increasingly emerged as part of modern day developments. In fact, India experienced a virtual explosion of public interest litigation, PILs, especially on environmental issues, and courts also assumed a more proactive role in the form of public educator, policymaker, and administrator. India even started contemplating to have a specialized tribunal dealing, especially with environmental matters, such as Supreme Court stressed on its importance in numerous instances. Well, here one interesting thing to mention that as per the legislation interventions or legal interventions, the environmental education was made compulsory up to certain levels, including school as well as in the colleges as well. So that is also another incorporation in this context. Finally, after much deliberations and failed attempts, National Green Tribunal was established in 2010. But since its inception, it has played an important role in shaping the environmental litigation in India. India started adopting a more holistic and comprehensive approach towards environmental protection and regulating the pollution emanating from industries. There are certain constitutional provisions as well for environmental protection. Indian Constitution is a living document which has evolved and grown with time. Substantive provisions for environmental rights and duties were lacking in original constitution because we can understand at that time it doesn't feel like there's a need to protect trees or water or it was not assumed that we are going to destruct it. But over the period of time, over exploitation, increase in population too much, we reached to a level that it has been realized that we have exploited too much. And then, as our constitution is taking regulation modification over the period of time, it was adapted that its landscape was changed by the way of 42nd Amendment, which introduced specific provisions for environmental protection in the form of directive principles of state policy and fundamental duties. With the introduction of these two articles, both the state and citizens are now under the constitutional obligation to protect, preserve, and safeguard the environment. As per the Article 21 these of the Indian Constitution, as I mentioned in the previous session within the slide, this today's session also, well, no person shall be deprived of his life or personal liberty except according to the procedures established by the law. So, Article 21 itself is the guiding one. And Supreme Court, in the case of Virendra Gaur, others versus State of Haryana, interpreted the word life in a liberal manner and stated that Article 21 protects right to life as a fundamental right. Well, enjoyment of life and its attainment, including the right to life with human dignity, encompasses within its ambit the protection and preservation of environmental ecological balance, free from pollution of air and water, sanitation, without which life cannot be enjoyed. Any contracts or actions that would cause environmental, ecological, air, water pollution, etc., should be regarded as amounting to violation of Article 21. Further, in case of MC Mehta versus Union of India, the Supreme Court treated the right to life in healthy and pollution-free environment as part of fundamental right to the life under the Article 21 of the Constitution. So Article 21 is some of the basis as well. Well, PIL under Article 32 and Article 226 also resulted in a wave of environmental litigation, producing a rich environmental jurisprudence in India. Well, thus over the period of time, Indian Constitution now guarantees a right to healthy environment, right to clean air, right to clean water, etc. As we can say, Article 19, subsection 1G of the Indian Constitution also confers fundamental right on every citizen to practice any profession or carry on any occupation, trade, or business, although it is subject to reasonable restrictions as well. In case of Burra Bazar fireworks, Dealers Association was a Commissioner of Police, Calcutta. It was held that Article 19(1)(g) of the Constitution does not guarantee the fundamental right to carry on trade or business which creates pollution or which takes away the community's safety, health, and peace. You can connect it somehow very clearly as well. Well, the environmental framework in India and its business on industries need a very, very thorough understanding, and we can see a good number of acts are there. They were introduced, they were incorporated in the Constitution over the period of time, part of amendments, which are somehow relate to the business activities as well, like Environmental Protection Act 1986, Water and Air Prevention and Control Pollution Act 1974, 81, Forest Conservation Act 1980, and Wildlife Protection Act 1972, etc. There are other acts also, so we can explore them separately. So in Environmental Protection Act, there are certain specific notifications like coastal regulation zone notification, that is called CRG, and according to this, it was a 2019 notification. CRZs have been classified under category CRZ 1A, B, CRZ second, third, and fourth, and they're further elaborated, and it has been mentioned that specifically which coastal zone is allowed for what purpose. Like CRZ 1A is ecologically sensitive, CRZ 1B intertidal zone, area between high tide line and low tide line, CRZ second developed areas up to the close to shoreline, and CRZ third land areas that are relatively undisturbed have further as divided into further A and B based on population density. As far as CRZ 4 is concerned, water areas and seabeds areas which are further divided into A and B on the basis of distance from low tide line. Well, here interesting is that the coastal line is very important because uh, from the coastal line, human settlements connect with the earth connects with the ocean, and ocean stability of ocean and ocean ecosystem is very important, crucial for the stability of environment as well. Because through this area, if we disturb the coastal line or coastlines, or we introduce waste uncontrollable in the ocean, what is happening is this the coastal line specifically has got very rich diversity. How we can say, if we go deeper in sea, so water level is very deep, no doubt, not to explain. So it is a place for a large size organism to survive over there. But consider what will be the place for the young creatures of these organisms. So ideally, this place that we call a shelf or coastal shelf or this area is a place where the larvae or young ones of these fishes or other creatures do survive over there. And this is the place where sunlight is easy level. So it has got a very huge diversity over there. And because of this huge diversity, it has got a specific water quality, soil quality, sunlight, depth, and other conditions. So this gives the ideal condition for a huge, diverse population to survive. And once this population is able to survive or grow, it goes back to the deeper ocean. So it is a basically culturing ground. Any intended or unintended disruption in this area, you can understand that it will be affecting the nursery of a population. So if you affecting the nursery of population, definitely it's going to create an imbalance in the deeper seas. So to address that issue that we are not indirectly or directly affecting the deeper sea population, it has been understood we need to look forward for the stability of this particular area as well. Well, then there is another aspect that is called as environmental impact assessment. So it is very interesting and important aspect with reference to industries. Initially, it was initiated in 1994. Well, the some of the current notification is of 2006, which lays out a detailed process for obtaining prior environmental clearance for any new projects or activities, or the expansion or modernization of existing projects and projects seeking capacity addition with change in process or technology. Well, it has been categorized into category A and B. Category A projects require their clearance from the Ministry of Environment, Forest and Climate Change, that is MOEFCC, while category B projects apply for the clearance to the State Environmental Impact Assessment Authority, SEIAA. Well, as I mentioned in the previous slide, that is EIA, environmental impact assessment, we can understand that if there is a need for a setting up of any project or expansion, modification, including addition of new technology, so there is a need for a clearance from respective agencies at the ministry or state level, state or central level. And these kind of expansion, while expansions are carried out. So the question is uh, exactly, if this process is to take place, what is the alternate? If we are going for the best one, or alternate is the best one, or existing is the best one, how it is going to change the socio-economic as well as the environmental aspect of that area. Is it going to alter something that is altogether in situ or for this area only? So, if there is the alternate option that is more environmental viable, that is to be taken. So, environmental cost or cost of environmental degradation is also incorporated for consideration or taking decision in this direction. Well, as far as the Forest Conservation Act of 1980 is concerned, it lays down the provision that regulate the diversification of forest land for non-forest purposes, etc. Then Wildlife Protection Act Then if there are implementation and compliances which are there for enforcement purposes, then for judicial purposes, we mentioned that there is an NGT, National Green Tribunal, which was established in year 2010 and which has got the objective to make environmental justice accessible, effective, and expeditious in India. Then India is contributed to the concept of management of climate change. Also, it has got some national action plan on climate change. It was in 2008, and has been a leading host country for clean development mechanism investment, uh, enabling an action one countries to invest emission reduction projects, thereby earning certified emission reductions. India has emerged as the second largest beneficiary to China in CDM projects. Its shares in CDM projects is around 20%, while of China is 50%, and share in CIR is 13%, whereas China it is 60%. Well, the opportunities for CDM in energy sector, electric vehicle sector are many. India submitted its intended nationally determined contribution in October 2015, which gives an outline of post-2020 climate actions the country shall take. India is a founder member of International Solar Alliance, launched in 2015 itself. Recently, at COP, India made an announcement of new climate action target and has indicated that it shall be carbon neutral by 2070. There are schemes from the government which are market based, like perform and achieve trade, green bonds, like Security and Exchange Board. Also introduce something micro MSME to promote new and green technology. Then zero defect certification scheme for promoting innovation, rural industry and entrepreneurship, Aspire, and creating capital subsidy for technology upgradation, that is CLCSS, will to facilitate technology upgradation of MSCs by providing an upfront capital subsidy to 15% on institutional finance of up to 1 crore availed by them for induction of well-established and improved technology in a specified 15 subsectors products approved. Well, there are certain important developments also, like environmental audit. Although it is not mandatory, but some states of Gujarat, Maharashtra, and Karnataka offer incentives to industries unit to obtaining ISO certification in this regard. Well, there are incentives which are for longer validity of consent authorization, then expeditious clearance of renewal applications, etc. So with this, we have summarily covered the environmental and sustainability related concept. It is an interesting one. I hope you go back and explore it in detail. Then there is another aspect of competition law, as I mentioned in the very beginning. Industries to start, run, and survive need to compete with each other. So competition is a healthy word, but under unhealthy practices, ethical practices, one industry may try to murder another one. If I use the word murder, maybe it's a harsh word, but it happens so that under monopoly condition, one industry will earn all the profits. So to do this, they carry out a lot of practices, day-to-day evolving practices, like putting their product or pushing their product at a cheaper rate, to which the rival company. So they lower down the profit, and with that lower profit, range of profit, a rival company cannot sustain for a longer time, if we say so, while a multinational or a bigger company can survive with that meager profit. And over the period of time, when this sustainability of one industry is not at all viable, it loses the market, it is wiped out from the market. Then only a single industry is there, and it monopolizes, and then now it can manipulate its price or so cost. So it is altogether making sort of effect which manipulate the market, which maybe initially seems to be favorable for the customer or consumer, but later on for a longer cycle it is not so. So competition law, which also referred to as antitrust law in some jurisdictions, play a pivotal role in ensuring smooth functioning of a dynamic market economy. Well, the competition law concerns itself with firms enjoying undisputed market power, which opens up the possibility of hindering consumer welfare by increasing prices, reducing output, diminishing product quality, and suppressing innovation as well. Well, as far as the historical aspect of Indian competition law is concerned, the Indian constitutional law has been drafted carefully with several measures aimed at safeguarding diverse rights that can contribute to the flourishing, specifically to the flourishing of the country as well as its citizen. Article 38, 39, though having been placed in Part 4 of the Constitution as directive principle of the state policy and unenforceable. Coincidentally, in the code of law, have proven extremely significant and laid down directions for good governance of the state. Well, as far as the Monopolies and Restrictive Trade Practices Act 1969 is concerned, MRTP Act was enacted to control monopolies to ensure that the economic system does not terminate in concentration of economic power and to disallow monopolistic and restrictive trade practices. Well, it highlighted in the second phase, ranging from 1991 to present, was bringing forth market-oriented economic policies with the coming of new economic policy (NEP) that needed to be in tune with the rise of globalization, liberalization, and privatization. Or if we use a typical word, that is LPG, liberalization, globalization, and privatization. As far as the Raghav Committee report, the call seeking a shift of focus from restraining monopolies to the promotion of competition was one of the primary reasons of the MRTP Act becoming obsolete, thereby paving way for new legislation. What ensured was the appointment of High-Level Committee on Competition Policy and Law in 1999, often referred as Raghav Committee. The committee was responsible for providing suggestions for the establishment of suitable legislative framework for competition law and recommended changes in the relation to restrictive trade practices. There is Competition Act 2002, then anti-competition agreements, then all enterprises as well as the which includes cartels shall be presumed to have an appreciable adverse effect on competition and shall be considered anti-competitive per se if they result in following certain determination of sale prices, output control, market allocation, bid rigging, and collusive bidding. Well, there are vertical agreements. Vertical agreements are agreements between persons and enterprises at different levels of the production chain in distinct market in relation to production, distribution, supply, storage, or price of goods or provision of services. Unlike horizontal agreements, vertical agreements are not anti-competitive per se, and it's need to be established that the alleged activity has caused an appreciable adverse effect on the competition, that is AAEC in the country. Vertical agreements also comprise of certain components like tie-in agreements, exclusive supply agreement, exclusive distribution agreement, refusal to deal, and resale price maintenance. They are further individually explored as well. And relevant market is concerned, under the statutory framework of the Competition Act, the delineation of a relevant market is the utmost significance. For an abuse of dominance investigation, an enterprise shall be considered dominant only if it has attained a position of strength in the relevant market. Determination of a relevant market is also significant in the combination analysis, where the CCI has to ensure that the proposed combination does not result in appreciable adverse effect on the competition. As far as the abuse of dominance is concerned, under competition law, mere dominance exerted by a firm is neither considered bad nor held punishable. However, the abuse of its dominance by an enterprise merits investigation by the competition authorities. This is in contrast with the earlier legislative framework as under the erstwhile MRTP Act. Violations were gauged based on the size of the enterprise rather than the abusive conduct of the latter. Then there are mergers and combinations. One of the significant business development in the field of corporate law has been a plethora of transactions encompassing mergers and acquisitions. The rationale behind companies opting to merge may range from increasing market power power, economies of scope, economies of scale, synergistic gains, eliminating competition, obtaining access to R&D and technological know-hows. Uh, well, we can see so that let's suppose there are two industries in the almost similar field, and one industry who is of a smaller in size but very good R&D, whereas another industry which is of larger size that is good in production but not in R&D. So it is in the best interest to combine both the industries and utilize the R&D of one industry or one setup or organization and utilize in the production in the other one. So they cumulatively, although they are working in the same segment or same section or same market, but since their specialization was different, their expertise were different. So with this merger, definitely they will be leading to a new profitable venture, if I say so. Well, as far as the enforcement of competition law is concerned, the Competition Law Acts also provides multi-tiered enforcement mechanisms. Uh, as per the provisions of the Competition Act, the Commission can inquire into any alleged infringement of Section 3(1), Section 4(1) of the Competition Act based on its own motion or on receipt or any information or by reference received from a central government, state government, or any statutory authority. Under the statute, there is no locus standi requirement. The CCI, after the receipt of information, is expected to satisfy itself as to the existence of a prima facie case and pass directions to the Director General under the Section 26(1) for initiating investigations. Well, the structure is concerned, it involves Director General, then Competition Commission of India, then appellate authorities, as far as the appellate authority is concerned. It has got National Company Law Appellate Tribunal, that is NCLAT. Well, it has been designated as an appellate tribunal for handling the appeals arising from the CCI. The appellate body has been empowered to hear and dispose of appeals against any order, direction, or decision issued by CCI. Well, let's move to the last unit, that is the consumer protection laws. As I mentioned that in any business, consumer is also a component because all the business activities are centric towards the consumer. Um, Maybe it is if it is B2C or if it is B2B, one part is consumer based on the usage pattern. So to safeguard their rights, definitely we have consumer protection law. In 1930, when the USA was facing great recession, the then president of USA, Herbert Hoover, while addressing a Congress, had remarked, economic depression cannot be cured by legislative action or executive pronouncement. Economic wounds must be healed by the action of the cells of the economic body, the procedures and consumers themselves. So here it was sort of enabling to the consumers themselves rather than the input from the legislature's system. Well, in every economy, the service standard products, services has to be sacrificed for the producers, providers of quality goods services, which will have an overall impact on the economy. Well, the consumer protection, we can see it's not new. In Indian context, including Cordelia's Arthashastra, the modern consumer movement, worldwide initiative by US President John F. Kennedy in 1952 referred to four consumer rights in his famous speech in the US Congress. And since then, 15th March was celebrated as World Consumer Rights Day on the initiative of Consumer International and International Consumer Association, formerly known as Consumer Union. 1985, UN adopted the Consumer Protection Guidelines, and one of the mandate of these guidelines for these signatory countries was to pass consumer protection legislations in their respective countries. India, being the signatory of the guidelines, became the forerunner to pass the Consumer Protection Act in 1986, based on the global cues as well. Well, in view, it is deemed expedient to repeal the extant law and enact a new law, namely Consumer Protection Act 2019, which was eventually notified on 20th July 2020. Well, the provisions of new Consumer Protection Act will have an impact on revolutionizing the Indian justice delivery system in the consumer cases. Well, Consumer Protection Act 2019 is really comprehensive and added various new features in comparison to the earliest regime, that is Consumer Protection Act of 1986. Well, main provisions that are covered with a special focus on newly added provisions are consumer authorities under the Act, who can file case, definition of consumer, process of filing complaint and online complaint, mediation under the Consumer Protection Act, e-commerce issues and challenges, product liability under the Consumer Protection Act, Central Consumer Protection Authority offenses and penalties. So the new addition is, if I what I can see is at least the major one is the e-commerce issues and challenges, because we day to day deal with some type of e-commerce activity, and now the online payment mechanism has been taking place on app-based payments, app-based purchases are there. So a lot of things are involved there. Well, as far as the consumer authorities under the acts are concerned, so there is a consumer protection councils, there is consumer central consumer protection authority, then consumer dispute redressal commissions, then mediation cells as well. And the mediation cells are described under section 74 to 81 of the act. There are certain powers that are vested with the commissions irrespective of their hierarchy. That is in the form of a chart on the your text you can go for. The district commission up to 1 crore, state commission 1 crore to 10 crore, national commission about 10 crore, Supreme Court revision and appellate jurisdiction, national commission original review and revision appellate, then state commission, then district level. So it is in the as far as the range is concerned, first three you can go for district commission up to 1 crore or so. Well, is in case of appeal from district level, district commission, original and review jurisdiction, then supreme, then state commission, then national commission, and Supreme Court also. Well, as far as the system of appeal is concerned, to district commission, to state commission, to national commission, to the Supreme Court, and there is a time gap, from district commission to state commission within 30 days from the date of order, and subsequently like that only. So from one level to another level within the 13 days of passing of that order. Then the process of complaint is also mentioned. The complainant may be a consumer, any voluntary consumer association registered under any law for the time being enforced, the central government or any state government, the Central Consumer Protection Authority (CCPA), one or more consumers where there are numerous consumers having the same interest. In case of death of a consumer, his legal heir or legal representative. In case of a consumer being a minor, his parent or a legal guardian. Well, if we need to go for the definition of a consumer being any person who buys any goods or hires services for a consideration and includes any user of such goods with the approval of buyer. But if goods are bought or services are hired for resale or for any commercial purpose, the case falls outside this act. So then that is the B2B category. It also has been made clear that if a person uses the goods bought exclusively for purpose of earning his livelihoods by means of self-employment, she is still a consumer and may avail the remedy under the act. Well, the new act also includes online transactions, as I mentioned, through electronic means, teleshopping, direct selling, multi-level marketing, and direct. Section 2, subsection C contains a definition of a complaint, which means any allegation in writing made by complainant or for obtaining any relief provided by or under this act, and unfair contract or unfair trade practice or restricted trade practice has been adopted by any trade or service provider. The goods brought by him or agreed to be bought by him suffer from one or more defects. The services hired or availed of or agreed to be hired or availed by him suffer from any deficiency. Well, a trader or service provider, as the case may be, has charged for goods or services mentioned in the complaint. The price is in excess to the price which is fixed by or under any law of the same time, displayed on the goods or any package containing such goods displayed on the price list, exhibited by him by or under any law for the time being enforced, agreed between the parties. Then there is a process for filing the complaints. Then, as I mentioned, it has evolved. So there is a online option also available. Then then there is a procedure to be filed at the time and after the complaint. Like there is a specific gap between the complaint can be filed, what document need to be maintained, and there are certain limitations. The period is the limitation required to file before the commission is 2 years from the date to which the cause action is arising. However, complaint may be entertained after the said period if the complainant satisfies the commission that he had sufficient cause for not filing complaint within such period, and if such a complaint is entertained by the commission, then reasons for condoning such deal is also mentioned. And relief that can be granted or execution of orders by consumer forums, removal of defects or deficiencies in the service, replacement of goods, refund of prices, award of compensation for the loss of injury suffered, may also award punitive damages, discontinue and not to repeat unfair trade practices or restrictive trade practices, to withdraw hazardous goods from being offered for sale, to seize manufacture of hazardous goods and desist from offering services which are hazardous in nature. Well, if the loss of or injury has been suffered by a large number of consumers who are not identifiable conveniently, to pay such sum not less than 5% of value of such defective goods or services provided, which shall be determined by the forum, to issue corrective advertisement to utilize the effect of misleading advertisements, to seize and desist from issuing any misleading advertisement, to provide adequate cost to parties. Well, as noted above, some new types of orders may be passed by the consumer for under 2019 Act, which will improve effectiveness of the Act, particularly in the area of misleading advertisement. The order against any companies or individuals to issue corrective advertisements also there. So, in this regard, we can see a recent information on news in the scenario that there are certain brand ambassadors, those are celebrities who are promoting any product. Now it is advised first use those products and only then it's better to go for becoming a brand ambassador. Powers of central there are powers that are vested with the respective authorities, with the central, with the state. Then there are liabilities associated with the product that I also mentioned. Now this is the new venture, that is e-commerce. This it involves protection regime under Act, covers all modes of transaction, offline, online, through electronic means, teleshopping, direct selling, or multi-level marketing. In order to regulate e-commerce sector in India and to protect consumer from unfair trade practices in e-commerce, Consumer Protection Rule 2020 were passed, which came into effect from 23rd July 2020, and these rules put a lot of duties on the e-commerce entities in the interest of consumers. Well, they are applicable to all goods and services bought or sold over word digital electronic network, all models, all e-commerce retails, all forms of unfair trade practices across all models of e-commerce. Well, there are certain limitations as well. These shall not apply to any activity of a natural person carried out in a personal capacity, not being part of any professional commercial activity undertaken on a regular or systematic basis. Then there are duties associated with the e-commerce entities, their name, their management, their operation, and no e-commerce entity shall manipulate the price of goods or services offered on its platform in such a manner as to gain unreasonable profit, discriminate between consumers of the same class, or make any arbitrary classification consumer affecting their rights under the Act. Then there are liabilities of marketplace e-commerce entities as well. Well, through this process, there is a process of mediation also. In case of there is a issue related to errors, related to problems, then there is a process of mediations also. So, in fact, we can consider the consumer protection law is very enabling and very evolving also. So, with this, I wish to conclude today's session. I think, thank you very much.